Okay, so let's try and unpack this. It's quite a situation, right? You have this global music icon.
Absolutely huge figure.
Yeah, generations know his songs, and then bam, serious accusations hit.
Right.
But the response isn't just, no, I didn't. It's this massive legal countermove.
The full-on counterpunch, basically, claiming it's all, well, an extortion plot.
Exactly.
And for this deep dive, we're focusing on one specific thing, a legal document.
Right.
It's called a cross-complaint, filed in California Superior Court by William Robinson Jr., everyone knows him as Smokey Robinson, and his wife, Frances Robinson.
Yeah.
And they're filing this against the people who sued them first.
The original plaintiffs.
Yeah, the original plaintiffs who are called Jane Does 1 through 4 in the paperwork, plus their lawyers, John W. Harris and Herbert John Hayden, their firm. And, you know, these placeholders called ROES for anyone else they might add later.
We're trying to understand the story the Robinsons are telling through their legal claims in this filing.
Precisely. It's their perspective, their narrative as laid out in court.
So to get that perspective, the document starts by painting a picture of who Smokey Robinson is.
It does. It talks about him being, you know, the legend, career spanning over 70 years.
70 years. And the filing actually lists highlights, doesn't it? Founding the Miracle.
Yeah, the very first group signed to Motown. And the hits, You've Really Got a Hold on Me, Tears of a Clown, I Second That Emotion. So many huge songs.
And writing for others, too. My Girl for the Temptations. My Guy.
Right. Incredibly influential. The document even mentions the Beatles and the Rolling Stones covering his songs. It emphasizes his stature.
And the awards. Grammys Rock and Roll Hall of Fame twice.
National Medal of Arts, Kennedy Center honoree, Gershwin Prize. The list goes on. And importantly, the filing notes, he's still active, touring, new album just out.
Which really underscores why these accusations and this countersuit are so high stakes for him and his reputation now.
Absolutely. It sets up the potential damage. Then there's Frances Robinson.
His wife, nearly 25 years, the document says, an interior designer.
And the filing makes a point of saying she worked with him on their homes and that she had this really close personal connection with the Jane Doe plaintiffs. It emphasizes the emotional impact on her specifically.
Okay, so who are these Jane Doe plaintiffs, according to this filing?
Well, the document describes them as former household employees. Some started working there way back, like 2007.
So long-term employees for some of them?
Seems like it. And a really central point the Robinsons make in this cross-complaint is how they say they treated them, not just as staff.
But like family.
Exactly.
Hey.
Like trusted, extended family members. That's the relationship they describe in the document.
Which naturally leads right into their main argument in this filing.
Which is?
That the abuse allegations made by these Jane Does, they claim they're totally fabricated. Yeah. And part of what the document calls an extortionate scheme. Their words designed to take everything from the Robinsons. Pretty strong stuff.
Very strong. And to back that up, the filing points to evidence exhibits attached to the documents that they say shows a completely different kind of relationship.
Okay, like what kind of evidence?
Well, they mention text messages, supposedly from the plaintiffs. Exhibit A, B, C, things like, love you, happy birthday wishes. Even an invitation, apparently, for Mr. Robinson to attend one plaintiff's son's graduation dinner.
Trying to paint a picture of warmth and closeness, then.
Definitely. They also allege vacations together. Mrs. Robinson taking plaintiffs to Cabo, for instance, paid for by the Robinsons. There's supposedly a photo exhibit for that, Exhibit D.
On the holidays.
Holidays, too. Exchanging gifts, celebrating together. They even mention a photo, Exhibit E, from a Christmas party where Smokey is dressed as Santa and the plaintiffs are there in the picture.
Okay, so personal interactions. What about, like, financial support?
The document goes into a lot of detail there. Alleges thousands of dollars given directly, help for the plaintiff's family members, clothes, even dental surgery paid for, providing a car for one. And Exhibit S is mentioned, a photo supposedly showing a theme park trip with the plaintiff's grandkids and Mrs. Robinson's family, all paid for by them.
So the argument is, we were incredibly generous, treated them like family. How could these accusations be true?
That seems to be the core of it. They even claim the relationships continued after some stopped working there. One plaintiff moved away to Chicago. But the filing says she stayed in touch, visited, came to concerts, got tickets directly from Mr. Robinson.
Okay. There's also a specific story about one plaintiff quitting and coming back.
Yes, that's a key point they make. According to the document, one plaintiff allegedly quit her job after they refused to give her $10,000 she asked for her son.
Okay.
But then, the Robinsons claim, she later returned to work for them. And the significance of this, as argued in the filing, is that she's now alleging abuse happened during that first period of employment.
Before she quit and came back.
Right. So the Robinsons are basically asking, if it was so bad, why would she come back? They argue it undermines the claim that the plaintiffs were too scared to speak up earlier.
Okay. That does add a layer to their narrative. So that's the relationship background they're presenting. How do they say things unraveled into this legal fight?
Well, according to the cross-complaint, it started in 2024 when 3 of the plaintiffs just stopped showing up for work, quit without notice.
Okay, abrupt departure. And then?
Then, the filing alleges, things escalated quickly. These plaintiffs got lawyers, Harris and Hayden, and through those lawyers, they allegedly made a demand.
A financial demand.
A huge one. The document claims they demanded $100 million or more.
Wow. Okay. That's a number.
A very big number. And the Robinsons, in their filing, say they resisted this demand.
So the demand wasn't met.
Apparently not. And according to the cross-complaint, that's when the plaintiffs filed their lawsuit, using the Jane Doe names to protect their identities.
Right. But the Robinsons' filing puts a lot of focus on what happened after that lawsuit was filed.
It does. It points to a specific date, May 6th, 2025. They allege that on that day, the plaintiffs and their lawyers deliberately held a press conference.
A public event.
A very public event. And the Robinsons document claims that at this press conference, one of the lawyers, John Harris, made statements they considered defamatory.
What kind of statements?
The filing quotes specific phrases allegedly used, calling Mr. Robinson a serial and sick rapist and a serial assaulter.
Whoa. Okay, those are extremely serious accusations to make publicly.
Extremely. And the filing alleges the plaintiffs themselves were at this press conference, visible, even though they were wearing masks and sunglasses.
And this got media attention.
Massive global media coverage, according to the document, which of course amplifies the impact of those alleged statements.
Yeah, naturally.
The Robinsons filing also claims that the lawyer, Harris, sort of, dared the media to dig into who the plaintiffs were, mentioning things like immigration status or cultural stigma as reasons they hadn't gone to the police, while simultaneously making these very public accusations.
Okay, so this press conference is a major focus of the Robinsons' countersuit.
It seems to be. And it leads to a really interesting legal point they make in their filing about something called litigation privilege.
Right. What's that about?
Well, generally, things you say in a court document, like the initial complaint the plaintiffs filed, are protected. You usually can't be sued for defamation just based on allegations made within the lawsuit itself. That's litigation privilege.
Okay, it protects statements inside the court case.
Exactly. But the Robinsons argue very explicitly in their cross-complaint that this protection does not cover statements made outside the court, like at a press conference aimed at the general public and the media.
Ah, so they're saying the press conference statements are not privileged.
That's their argument. They're saying those statements are fair game for a defamation lawsuit because they weren't part of the official court filing process. They were public pronouncements.
Which makes sense why they focus so heavily on it. It's the basis for their own legal claims.
Absolutely. Which brings us to the actual causes of action, the specific legal claims the Robinsons are making in this document. Remember, this is all according to their filing.
Okay, what are they claiming?
First up is defamation per se, specifically slander. They're pointing directly at those alleged press conference statements. Serial and sick rapist. Serial assaulter.
Per se meaning?
Meaning the words themselves are considered so damaging, especially accusing someone of serious crimes, that the law presumes harm to reputation. You don't necessarily have to prove specific financial losses initially. They claim these statements were false and deeply damaging.
Okay, defamation is claim number one. What else?
There's also a claim for false light. It's related to defamation, but slightly different. The idea is that the press conference and the statements portrayed Mr. Robinson falsely to the public in a way that's highly offensive, created a false impression.
Got it. So damaging reputation, creating a false image. What about emotional impact?
That's covered too. They have claims for both intentional infliction of emotional distress and negligent infliction of emotional distress.
What's the basis for that?
They argue the alleged conduct, specifically calling out the slanderous press conference and something else we haven't detailed yet, and alleged deletion of evidence from Mrs. Robinson's phone.
Oh, okay. We'll need to circle back to that.
Yes. They claim this conduct was outrageous and caused them severe emotional suffering, either intentionally or through negligence.
Right. What about the idea of them all working together?
That's the civil conspiracy claim. The Robinsons allege that the plaintiffs, their lawyers, the law firm, all the cross-defendants conspired, basically worked together with a common plan.
To do what?
To unlawfully enrich themselves at the Robinsons' expense. And the filing specifically mentions the means included extortion by defamation. So using defamation as a tool in this alleged conspiracy to get money.
Okay, that connects back to the extortion claim. Now, there was something unusual mentioned in the outline. Elder abuse.
Yes, financial elder abuse. This is a specific claim under California law. The document states the Robinsons are over 65, making them elders legally.
Mm-hmm.
And they allege the cross-defendants committed financial abuse, not just by potentially taking money or property, but significantly by acts like defaming them, which they claim caused loss of income, damage to assets, specifically because of their age and potential vulnerability as elders.
So, leveraging their status as elders under the law, does that law carry extra penalties?
It can, yes. California's elder abuse laws allow for potential recovery of attorney's fees and significantly treble damages, meaning triple the amount of actual damages awarded.
Wow, okay. So that's a potentially powerful claim. Now, shifting gears slightly, what about actual property? Theft?
Yes, there's a claim for conversion. That's essentially the civil law term for theft or wrongfully taking someone's property.
Who are they accusing of conversion?
The filing points fingers mainly at the ROES, those placeholder defendants, but likely implying the plaintiffs or people connected to them. It alleges they unlawfully took personal property.
Like what?
The document gets specific. Items from a hidden safe, gold Krugerrands, and financial records.
Gold Krugerrands, a hidden safe. That sounds dramatic.
It does, and it ties back to the level of trust they claim existed. The filing mentions, for example, that one plaintiff allegedly had keys to the Robinsons' other homes in Vegas and Pittsburgh.
So access was significant.
Very significant, according to the filing. It even claims one plaintiff was named in Mrs. Robinson's will. They're really trying to emphasize the depth of the alleged betrayal of trust.
Okay. And related to taking things, there's an invasion of privacy claim.
Right. They allege intrusion into their private affairs. This covers the alleged theft of valuables and financial records, but also accessing and, crucially, deleting data from Mrs. Robinson's personal cell phone.
Okay, let's talk about that phone data deletion. That sounds serious.
It is, and it forms the basis of another very specific claim. Violation of California Penal Code, Section 502.
Penal Code. That sounds criminal.
It's a section of the criminal code, but it also allows for civil lawsuits. It deals with unauthorized access to computer systems.
And the allegation here is?
The Robinsons' filing alleges one specific plaintiff knowingly got into Mrs. Robinson's password-protected phone without permission.
Okay.
And deleted data from it. Critically, the filing claims this deleted data included exonerating text messages and photographs, things they say would have helped their case.
Exonerating evidence allegedly deleted.
Yes, and they claim this was done with the intent to defraud, deceive, extort, or wrongfully obtain property or data hitting the requirements of that penal code section.
So a whole raft of claims. Defamation, false light, emotional distress, conspiracy, elder abuse, conversion, invasion of privacy, and this specific computer access violation.
It's a comprehensive counterattack, legally speaking.
And what are they asking for in terms of damages based on all this?
The filing puts a number on it. They're asking for at least $500 million in actual and compensatory damages. That's for the alleged harm suffered.
$500 million, minimum.
Minimum for compensatory, but then they also ask for exemplary or punitive damages on top of that.
To punish the defendants.
Exactly. And remember, those treble damages for the elder abuse claim, they're asking for that too, plus attorney's fees, court costs, interest.
So potentially a massive amount of money if they were to win on all these claims.
Potentially, yes.
Yeah.
And the document concludes with a clear demand for a jury trial. They want a jury to hear all this and decide.
Okay, so pulling back a bit, what does this all mean for you, the listener, trying to make sense of this?
Well, first, it shows just how dramatically different the story can look depending on which legal document you're reading. The initial lawsuit presumably told one story.
And this cross-complaint tells a completely opposite one. Betrayal, extortion, media manipulation.
Right. It really highlights that legal battles, especially these high-profile ones, are often fought through competing narratives presented in court filings.
Yeah, and it gives us a window into the specific legal tools people can use to fight back. We see defamation law being used not just for libel in print, but slander from a press conference.
Exactly. We see how elder abuse laws can apply not just to scams, but potentially to reputational harm, causing financial loss to seniors.
And even tech-specific laws about accessing phones and deleting data coming into play?
It shows the breadth of legal arguments available.